Do you know what to do if you experience a serious illness while you're working? What about a medical emergency like a fractured bone or a twisted ankle? What are some of the things that you should expect from your HR department? What are some of the ways that you can protect yourself and protect your job? Today's video is going to cover these topics and more. Let's talk about it. Hi, I'm Harlow Reed. Welcome to the HR Insider. I'm an HR leader and legal professional, and on this channel, we talk about issues that matter to you most in the workplace. In today's video, we're breaking down a case involving Walmart, one of the largest employers in the world. We'll talk about what happened when one of their employees submitted a request for an accommodation due to a disability she had. I'm going to use that case to break down what your protections are and what you should expect if you encounter a temporary or permanent disability in the workplace. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. So always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. This story starts with Marlo Spaeth, and she was born with Down syndrome. And Marlo had the distinct physical characteristics of a person with that condition. So anyone looking at her could tell that she had type of a disability. She also had developmental delays that created a lifelong intellectual disability for her. And typically, persons with Down syndrome have the capabilities of someone aged 4 to 11. And this was consistent with Marlo's condition. She was also unable to drive a car, and she interviewed with Walmart in 1999. Her mother was with her, but her mother, Sandra Barnes, did not answer any of the questions. Marlo answered all of them, and ultimately she was hired as a part time employee on August 2nd, 1999. She worked at the Manitowoc, Wisconsin store. And after she was hired, she worked with someone named Karen Becker, who was a personnel coordinator. Karen sat with her and identified what her availability was. Her mother was also with her, and her mother said that Marlo could not work weekends and that her availability would have to be consistent with the bus schedule. She signed a scheduling availability form that said she was only available to work from 12:30 to 4 p.m. on Mondays, Tuesdays, Wednesdays, and Fridays, and that she required a minimum of 14 hours a week. When they agreed to do this, they essentially accommodated her condition. Did she have a medical that diagnosed her condition? No. But her employer could see from her physical characteristics and her interactions that she did have a disability. And so they agreed to this schedule to accommodate her disability. And during trial, Down syndrome specialist named Dr. David Smith, he actually testified that people who have Down syndrome, routine is especially important for them because if you take it away, it causes them a great deal of stress, somewhat like a trauma for someone who doesn't have the disability. Marlo worked as a sales associate, and Walmart actually assigned managers to her who were patient and who would take the time to teach her how to do her job. And in doing so, they also made another accommodation for her. Again, she has a disability, they are aware of it, and they're trying to help manage that disability by assigning leaders who were patient and would be willing to take the time to show her how to do something, more time than they would need to take with the average associate who did not have the disabilities that Marlo had. And they limited the type of work that she was assigned to do. For example, she was never asked to operate the cash register, but she was responsible for folding towels, tidying the aisles, helping customers locate items. She was responsible for maintaining her schedule. And these duties, along with her attendance and punctuality, these were identified as the essential functions of her job. Important that if you decide to request support and accommodation for a disability that you have, whether temporary or permanent, that you identify the essential functions of your job. They will be located in your job description prior to making a request for an accommodation. The reason for that is that the essential functions are those tasks that must be performed no matter what. If you have a disability or you do not have a disability, those tasks have to be done. If you are a surgeon, your essential function is surgery. If you are a receptionist, your essential function is talking. If you are a data entry operator, your essential function is typing. Those are the things that have to be performed in those jobs no matter what. So that's the first step. Identify what your essential functions are. The second step is to figure out what you need in terms of support to aid you in your condition, whether it's temporary or permanent. You need to look at whether or not your request could be considered unreasonable. And if it is considered unreasonable, then do I need to request it or what are my options there? If it is reasonable, then you can perform the essential functions of your job and you don't have an issue. But if it's unreasonable, then you can essentially work your way out of a job because you're saying to your employer, this is the accommodation I need to help me with my disability. And if your employer says, I cannot provide you what you are requesting because it is unreasonable, that means you can't perform your job. So, essential functions and making sure that you understand what they are and how they're going to be limited by whatever requests you are making to human resources is very important. So back to Marlo Spaeth and Walmart. So Marlo was put on a schedule that was consistent with her needs based on her disability. And she worked the same shift every single day on every day that she worked. And she took the public transportation, the bus to her home, arrived at 5 o'clock, had dinner, watched the same show that she watched every day, and then woke up the next day and did it again if it was a day that she was, of course, scheduled to work. And this was her schedule for 15 years. And during that time, she also received consistent performance reviews that were very good. She started out with a salary or an hourly rate of $5.50 an hour. And then she worked her way up to an hourly rate of $12.50 an hour. And so she had a very consistent routine and a steady increase that said the accommodations that her employer provided were working for her. Walmart identified traffic patterns in their store that left them without enough staff, sufficient staff to manage their business operations. So they created a directive and said, going forward, leaders who at the time had absolute discretion to modify hours, leaders could no longer have that discretion. And if they needed to modify hours, they had to submit a request. And the request was met with very strict, um, a very strict review of the discretion or the request that was being made. And so, because of that, a lot of managers did not want to make that request because basically it was frowned upon. And sure enough, employees, if they did not follow the schedule that was assigned to them, they would get no hours at all. And so, what happened with Marlo is that she had changes to her schedule and she could not meet the attendance requirements after she was assigned a new shift in 2014. Marlo made several requests to return to her prior schedule of working noon to 4, but each request was denied because store managers saw that the new scheduling protocols were not popular with anyone. Everyone was complaining about it. There were so many requests from Marlo's coworkers to return to their prior scheduling that her request was just lost in the shuffle and they didn't see it as any different from the other requests that they received. And on July 10th, Walmart terminated Marlo because of her attendance. By that time, she had over 17 attendance infractions, and After she was terminated, Marlowe's sister and her mother went to Walmart to discuss the reason why Marlowe was terminated. And they also expressed Walmart's need to accommodate Marlowe under the Americans with Disability Act. And they requested that she be given her job back and that her old work schedule be restored. The managers understood that Marlowe had been given accommodation, but they did not feel that the changes made to her schedule was in violation of the Americans with Disability Act. And the family firmly stated that they intended to sue Walmart if Marlowe was not given her job back and her old schedule back as well. And the HR director, following this conversation that Marlowe's family had with Walmart, advised these store managers to cease all communications with Marlowe and her family. So Marlowe and her family filed an EEOC claim, and the EEOC filed a lawsuit against Walmart for their failure to accommodate Marlowe's disability under the Americans with Disability Act. They said that they knew she needed an accommodation. They could do it without undue hardship, and they did not provide her any reasonable accommodation, and discharged her without reinstating her and giving her a chance to perform her job. And so the jury awarded Marlowe and her family $150,000 in compensatory damages and then 125 million in punitive damages. But it's important to note that that 125 was reduced to 150 because the EEOC has a cap of 300,000. So they were awarded 300,000 in total, and then there were also some additional fees that amounted like about $500,000 total that Walmart ended up having to pay. Employers are required to engage in what is called the interactive process when an employee requests a disability accommodation. And this interactive process is showing that they are giving consideration for what your needs are and that they are looking at whether or not it is going to create a hardship for them. So that this is where the essential functions come into play, understanding what your essential functions are and whether or not you are submitting a request that is unreasonable. In this case, in Marlowe's case, her request was more than reasonable. But there are times where employees will request, for example, I need Tuesdays and Thursdays off because I have to go to the gym, because I have to work out due to my condition. Well, that on an ongoing basis as a permanent change for a permanent disability can be problematic. For a temporary disability, it may not. If you've got a broken leg and you need to do therapy, then it's for a short interim period of time. That is not going to pose a hardship. But someone who's having a cognitive decline, which is a permanent disability, and they say they are unable to work on 2 or 3 days a week, then that does modify the essential functions of the job because it means that they are not going to be done. And remember, the essential functions of the job have to be done no matter what. So if it's a temporary disability, maybe someone else can cover what that employee is unable to do, or maybe that employee can work different hours or do things that would accommodate whatever the essential functions are. Or maybe the essential functions aren't done for a short period of time and that therefore it doesn't create a hardship. But these are things that your employer explores during that ADA interactive process. And making a reasonable accommodation followed by retaliation or termination is a clear violation of the ADA. So if something like that has happened to you, I would encourage you to reach out to the EEOC, talk with them, talk with the attorney, employment law attorney, who can assist you with understanding whether or not your rights have been violated. Disability rights affect all of us, whether it's through cases like Walmart and the EEOC or issues like dementia at work, which we covered in a recent video. These topics are critical for making sure that the work environment is safe and fair for everyone. If you found the information in this video insightful, please give it a thumbs up and share it with someone who could benefit from understanding more about workplace disability rights. Don't forget to subscribe and hit the notification bell so you don't miss future videos, including more case breakdowns and real life disability in the workplace.